In the second video, I would like to talk about one concrete right, namely the right to housing. And just like when talking about the prohibition of torture and inhumane and degrading treatment, it is not so much because it is fully representative of all rights in a category. Indeed, as I said in the previous clip, there are specific challenges, specific issues, specific questions that arise with each and every one of them. But it does provide us insight into some of the key concepts, such as, for example, the notion of justiciability, to which I will come in a second. And it also gives us somewhat of a hands-on view on what happens or how cases pan out. Now, as already mentioned in the previous clip, the right to housing is based in Article 11 of the International Covenant on Economic, Social and Cultural Rights, which I already mentioned in the previous clip as one article that includes, in fact, a number of rights. So let's have a look at it briefly. It establishes that the state parties recognize, I quote, the right of everyone to an adequate standard of living for himself and his family, including adequate food, clothing, and housing, and to the continuous improvement of living conditions. However, that's not the only provision that protects the right to housing, and in fact also not the only instrument. It's also mentioned in Article 25(1) of the Universal Declaration on Human Rights, in Article 14(2) of the Convention on the Elimination of All Forms of Discrimination Against Women, Article 43 of the International Convention on the Protection of the Rights of Migrant Workers and their Families, Article 28 of the Convention on the Rights of Persons with Disabilities. It is implied in Article 4, which is the right to life of the African Charter of Human and People's Rights. It's also implied in Article 8, the right to privacy, home, private life of the European Convention on Human Rights. It is part of the European Social Charter in Article 31, and it's also mentioned in Article 26 of the American Convention on Human Rights. So what's the point of having all these instruments and provisions if they essentially protect the same? And this was obviously the second question that I had for the readings. Now, there are a few arguments that can be put forward here to justify this, and I think all of them are very well taken. The first one obviously is we have a division between universal and regional instruments. So some of these, such as the European Social Charter, the American Convention, are in fact regional instruments, and therefore these rights are perhaps more appropriately protected and more appropriately also described for the regional context. Relatedly, but also as a sort of second and distinct point, it creates various treaty bodies, all of which do have a specific function or place in monitoring the compliance with these rights, including possibly the reception of individual communications. I give you some examples of such legal cases, legal actions in a second, which will make you appreciate the multiplicity of possibilities that individuals then have to bring forward their claims. And thirdly, the rights protections in these various instruments are not exactly equal, even with regard to the substance. When we look at particular groups such as women, migrant workers, persons with disabilities, their housing needs, their needs in order to have the right to housing effectively fulfilled might differ, and specific instruments will be able to much better address those specific needs, those specific aspects, which overall, taken together, might then enhance their realization. Now, just to put it up here, what's already described in the textbook and what most notably is explained in concrete detail in General Comment 4 of the Committee on Economic, Social and Cultural Rights, there are really various aspects, various requirements that are included in the right to housing, and taken together cumulatively, that they need to be fulfilled in order to effectively protect and fulfill this right. So let's then look at some concrete cases in which this right was at stake. And this also serves as an answer to the third question on the programmatic, so to say, character of economic, social and cultural rights. The first case that I wanted to mention, and it gets habitually referred to in this context, is the 1999 Grootboom case before the South African Constitutional Court. Without going into too much detail, what you need to know is that the post-apartheid South African constitution is considered to be very progressive, very far-reaching, also in particular with regards to economic, social and cultural rights. And in this particular case, a group of persons, including Mrs. Grootboom, who were poorer people and living in an informal settlement, were basically evicted and their houses were basically bulldozed in order to realize a housing project. And what the South African Constitutional Court held here was that, well, the South African government, despite having a coherent and coordinated housing program in the long term, so that's obviously the part of the progressive realization that we are talking about, still has some immediate short-term obligation. And this obligation includes in particular the need to have relief for people in desperate need under Article 26 of the South African Constitution, which is on the right to housing. The case is very famous because it's maybe one of the best, and definitely one of the earliest examples of the right to housing being regarded as justiciable. The person in this case, the applicant, actually had the right to demand immediate housing, and given her vulnerable state, the fact that she was somebody in a desperate need and a desperate situation, as the South African Constitutional Court put it, actually gave rise to positive obligation by the South African government to provide such housing. Another very illustrative case is from 2 years later, from 2001, and more specifically from the European Court of Human Rights in the case of Chapman versus the United Kingdom. Sally Chapman belongs to the Roma community and actually bought a piece of land to live there in her caravan and have her children go to school, but the local authorities did not give her the permit and did not allow for her to live there. The European Court of Human Rights, when faced with the question, actually sided with the local authorities and denied the Article 8, so the right to private life in a home, claim of Sally Chapman, most notably because there were other interests, public interests involved in having this site protected, and environmental reasons played an important role here. So this is a case with a negative outcome from a human rights standpoint, but it's important for two reasons. Firstly, there are obviously legitimate limitations that can be placed on the right to housing. And secondly, in this case, actually very famously, the European Court of Human Rights held that the convention did not provide for a positive obligation of states to provide people with a home. So this, in a way, is a reaffirmation of the programmatic character of the right to housing, and to some extent a blow to the argument that it is justiciable, at least when it comes to the positive obligation to provide for a home. The final case I want to mention is the 2006 case of FEANTSA versus France. And this is an interesting one because it was launched before the European Committee on Social Rights, which actually provides not for an individual complaint mechanism, but for a collective complaint mechanism. So it was actually FEANTSA as an NGO representing the interests of homeless persons that brought this case against France, arguing, to put it very simply, that what France had done so far to eradicate homelessness, to diminish the existence of substandard housing, had not been enough. And indeed, the committee agreed with the applicant organization and held on various grounds that what France had done so far was not sufficient. It's very interesting because even though we talk about progressive realization, that does not mean that a judicial body or quasi-judicial body such as the European Committee on Social Rights cannot actually review the progress made. And in this case it did, and in this case it found a violation of Article 31 of the European Social Charter. This concludes this video. I look forward to discussing the issues with you on Friday.